Hi, a common question I get, and it looks something like this. My wife and I, or my husband and I, own everything jointly. So if my spouse were to pass away first, I would inherit everything and avoid probate. Or if I were to pass away first, my spouse would get everything without probate. So we're avoiding probate. We don't need a written estate plan, right? Well, unfortunately, the answer to that is wrong. You're correct that if you do own everything jointly, and one spouse passes, either the husband or the wife, the other spouse does in fact get the assets, all of the joint assets, without probate. But all you've really done is pushed off when probate occurs. That when the second spouse passes, you're still going to have to go through probate. The other thing is that assumes that you do in fact own everything jointly. I can't tell you how many times in 17 plus years of practice I've had clients come in and say, well, we own everything jointly, only discover maybe one of the spouses owned an interest in a small business, or one of the spouses had a separate checking account, or one of the spouses owned a piece of real estate in their name only, whether it was a piece of hunting land or a cottage, or maybe had a partial interest in land that their family owned. If you have a situation like that, you could potentially end up going through probate twice, once upon the passing of the first spouse that had the individual asset, and then again upon the passing of the surviving spouse. The only way to make sure you absolutely avoid probate is through a properly funded and a properly set up revocable living trust. If you have any questions on estate planning, give us a call at 763-420-5087.